Well, I have here with me Peter Gregory, who's a very experienced court reporter, many years of court reporting with The Age and other newspapers, started in Queensland many years ago and is now a media academic working in the area and has written the book Court Reporting in Australia. Well, we're talking about court reporting, and I'm wondering, Peter, as a very experienced one, what you see as the greatest rewards that you got from your career in court reporting?
Okay, if I can give you one circumstance which will sound a little bit odd, because I guess over about 20 years here in Victoria, we covered a lot of the big, crime and civil cases. There was one in the federal court to do with dredging in Port Phillip Bay. And I was on the train on the way in to work. There were a man and a woman sitting reading The Age in front of me. So that was our paper, and they were reading my story. I'm thinking, oh, heaven help us. And at one point, the judge in the case had said, look, I'm not making a ruling about whether this practice is right or wrong. In effect, it's a question of whether all the right procedures had been followed. And that's what was in the story. And when I think it was a woman might have asked the fellow, oh, well, so what does the judge say? What's the judge saying about, is this a good thing? Oh, no, that's not what it means. What he's done is this, and has explained it out completely. And I actually felt really good about that, because I felt as though, A, I got a point that was important in the story, and B, somebody's reading it there as a member of the public and they're understanding it and they're able to tell it to someone else. And really, I thought that was the sort of our main point of being there, was to explain to the public what was going on. Indeed,
and there's a real art to court reporting, isn't there? In fact, you've got to navigate those legal difficulties but still make it a very interesting and compelling yarn. So what's your advice to rookies about how they do all of that?
Okay, well, the first thing I'd say is listen, because it's an art which seems not to be fully valued these days. Everyone's really keen on providing their opinion, whereas I guess in court reporting, that's not exactly what you're not doing. You're listening to what's going on. You're trying to interpret, and look, the way you write a story might be the different to the way I write a story, but nevertheless, you're trying to sum up in a relatively short space something that might have happened over 4 hours. So I guess listen, concentrate. I would always sort of mark good quotes or a passage that seemed to help me understand what was going on as I was travelling along. And then maybe at lunchtime, if I go back to pre-website days, at lunchtime I might have a look at some of those, and then after going to the afternoon session I could look again, and then at least you've got some idea of what your story would be. And I'd always have in my mind what's going to be the lead, and that might change during the day. So I'm listening, and I'm trying to anticipate what is the big point that I've heard, or what is the main thing I'm going to say, which is basic news reporting.
Well, that's great. And the defences to things like defamation and contempt of court in reporting court are premised on it being a fair and accurate report of the proceedings, not just that day, but the proceedings as a whole, overall, through the various trials and until an ultimate endpoint. What's the best practice for achieving that as a court reporter?
Okay, well, each day I would try to make sure I had something from the defence in there, even if it's if they had nothing happening, no submissions or evidence much that favoured the defence in a trial, you'd nevertheless indicate someone has pleaded not guilty, and if it had been outlined to the jury, this is what we say has happened, you would have that paragraph in as well. You'd also try and keep in touch with people at the court, so the prosecutor or defence counsel or maybe the judge's associate, as to when the defence was likely to start, so that you'd be in there at the right time. And look, in a way, and again, this sounds a little old-fashioned, but you'd turn up. It's really easy now to, for example, get results, so a sentencing remarks or a decision, and you don't need to turn up, and there's great access given by the courts, especially the Supreme Court these days. But even if you get that, turning up lets you see what's happening in court, and you can get a flavour of what's going on, as opposed to just doing something from a judgment.
I guess that's part of the problem with court reporting and with a a major newspaper like The Age, there are so many trials going on at any moment in different courts, just even forgetting the civil courts for a moment, just within the various criminal courts. For a court reporter, or perhaps two in a large organisation, but normally only one, to be able to cover. So how can you be all places at once, and how do you prioritise this?
Well, you can't be everywhere, I guess, and you've got to understand that. And the other side of it, I mean, if we go, whether it's now with the various digital opportunities to publish or even before then, there's only so many stories you can write in a day and only so many that are going to be run. So I guess you have to be selective at the start. You're choosing a major criminal trial, or you're ringing around in the morning or even the night before, if you can, to find out about some of the civil trials. Now, if you get a little bit of a heads up on something, I guess you can plan. And so I would maybe, in fact, what I would do is try to choose the hardest case to cover often when I've been doing it for quite a few years, because I figured I would be best placed to do that. And if there was, say, a murder trial, which might be, interesting, but there was someone who was less senior available to do it, then they could do that and I could concentrate on the difficult stuff. So you are selective. You can't possibly cover everything, but you're trying to make those judgments as early as you can.
It must be hard when you're not covering a case and there has been a suppression order issued during that day of the trial, so part of your routine must be double-checking that no such order has been issued in your absence.
Yeah, that's true too. I mean, I think there's, and again, from memory, you would get a notice of suppression orders, but you'd also check on the door of the court. And in a case maybe where you perceived there's some sensitivity, or if you had a memory of earlier hearings, or if you might just say, look, are there any suppression orders in this? Just to make sure that there wasn't something which stopped you from writing the things that you thought you would write. When I was in South Australia, and this is going back to the 1980s, perhaps the level of communication wasn't as great there as it is in Victoria, and you often found yourself being an expert at trying to work out what you could say and what you couldn't say, and write very precisely around the orders. And the advice then was, we don't give you legal advice, this is just what the order says. So you were having to try to second guess what the judge or magistrate meant. And look, we, touch wood, navigated ourselves around it reasonably successfully. So, but there is, I guess, a knack in doing that, and part of it is just doing it often.
I know in South Australia, a magistrate or judge under legislation has to actually turn to the media at the point of a suppression order being issued and ask whether they have any submissions to make. And it's not the practice everywhere, but I do know in some small locations, sometimes journalists do stand up and take that opportunity. Did you ever do that, or do you have any advice to journalists about how to do that?
Yeah, judges did turn to us, and we noticed the members of the media in court, and I guess we would talk broadly about principles, or we might say, well, look, Your Honour, we think this is... You don't need to completely suppress proceedings if you're concerned about this particular bit of information. I think there was one time when we negotiated with a barrister about what sorts of information they wanted suppressed, and basically managed to narrow it considerably, but that wasn't typical. I know I had a pretty good relationship with the media lawyers at The Age, and if I thought it was serious, then I would be able to talk to them. It's not the same now because there are, great limitations on budgets, and whereas I guess it was less so in those days.
So reporters today might actually have to step up and do some of this themselves rather than just making a call for a lawyer to run down to assist them.
Yeah, and it's not impossible for that to happen. I think part of it too. I kept saying it wasn't really our fault, but I guess before. You had the multiple media people coming down to court. If I went back 20, 25 years here in Victoria, you would typically be The Age, the Herald, the old Herald, and then the Sun. The ABC would be there, and then from the TVs would come down from time to time, but you wouldn't get the same daily coverage. And of course, if they get used to the same people being in the same courts, and we understand where the limits are, there perhaps are fewer orders made. And the fact that people would come in, and I remember people sort of say, oh, well, look, we know we don't need to make this, and we know there are experienced people here in court, but, we don't know who the other people are. And there was almost this idea that we need to take account of people who don't have a lot of experience.
I'm sure sometimes you also get a lot of pressures from the newsroom as a court reporter, from people who may be in a senior editorial position but don't necessarily understand the legal requirements that are involved and that fairness and accuracy requirement and the sub judice restrictions. Does that happen from time to time, that they're asking you to go a step too far in court reporting?
Look, they weren't too bad at the age. It would often be about details of the way someone might like to write the story. So occasionally a sub-editor might say to you, why can't we say this? And then I would explain. Or I would typically leave notes on the top of my story. So if you talk about tips for young players, if you think there's a problem, make sure you tell the sub-editors or the news desk when you're sending your story through, give them some notes, tell them what's going on. So I might say, it's really important to have this paragraph in because this is the fellow's defence and they made a big point of it in court today. That sort of preemptive communication probably saved a few problems. I used to keep scrapbooks as well. So there was one time when, for example, somebody, I think there was in the Voyager cases here in Victoria, which related to a 1964 collision between two naval vessels, and they were still going. When I left, there were still Voyager cases going. At one point, there was a settlement in Western Australia, and we obviously didn't know about it, but it related to a Victorian person. And somebody from the news desk said, we believe this is the biggest, settlement of its kind, and it's a record or whatever. And I said, well, hang on a second. I reckon I covered something about this a couple of months ago. Went back through my scrapbook, found it. The one that I covered was bigger. And he said, oh, it must be one of the biggest then. I said, okay, yeah, we can say that. So it's really probably a question of, can you prove what you're going to say to the public and to your news desk? And do you keep records?
And I guess the scrapbook now is a digital one for most people, and it's quite easily searchable, which really brings us to our final question area, and that is this devices and new media, social media in the courtroom. I mean, you must see enormous changes with the use of this, with bloggers and tweeters in court. How is this impacting on everything?
Well, look, when I was covering courts regularly, it was coming in probably as I left. I did actually go back and I filled in for someone at the Jill Maher case last year covering the sentencing. And in the end, my issues were not the tablet. My issues were that the deadlines were much later at night. So having been there at 10 o'clock in the morning, I was still writing at 10:30 at night. But look, I guess part of the issue will be sending stuff out really quickly, and then somebody objects to a piece of evidence and they say, well, no, this can't be part of the record, or something gets suppressed. Now, I've heard in some jurisdictions, you'll probably know better than I do, there's almost an idea that you have a short delay between...
That's South Australia. There's a 15-minute delay there under the legislation now.
Yeah, and I think that I would be guessing that the court reporters wouldn't entirely think that's terrible because it gives them time to compose themselves. Whereas I guess the issue is, if you're wanting to be right, you have to be fair and accurate. Banging stuff out really, really quickly like that is a difficulty. Even the radio reporters from the past who'd be going out at the 20 minutes to the hour or whatever, they would be writing stories while taking notes, but they had a little bit of time at least, whereas now there's almost an expectation. And if you see from the Pistorius trial, just the one in England with Rebecca Brooks, there's just tweet. So it would take a great deal of concentration, I would think. In one sense, it would be really exciting to do it. In another sense, I'm not that unhappy I'm not.
Well, Peter, thank you so much for sharing all this expertise on court reporting with us today. You've raised some fascinating issues, and we look forward to talking with you another time. Thanks, Peter Gregory.
Thanks, Mark.